conservatory orders are granted on the inherent merit of a case, bearing in mind public interest, the constitutional values, and the proportionate magnitude and priority levels attributed to the relevant case. Further, conservatory orders are issued in exercise of the discretion of a court.
Yes.
The second interested party relied on the case of Gatirao Peter Munya versus Dixon Mwenda Kithinji and two others. That's at 20, the citation is 2014 EKLR for the courts that have made on the conservatory order being public in nature. And therefore, what is more important in this case is that the constitutional edict to be protected and that it be observed by members of the Senate and of the County Assembly elected as representatives of Kenyans, the citizens of Kenya. Therefore, misuse of such powers that the members of the County Assembly and the Senate have should not be allowed by the court. It is on this premise that we implore the court to uphold the conservatory orders and that the same to not be set aside. And to my second issue on the exercise of discretion by the court. My Lord, the court is alive to the social constructs in Kenya, the patriarchy in our societies, and the general dynamics of our society.
Just a moment, Counsel. Did FIDA file an affidavit?
No.
So I think we can just skip the observations about the general nature of our society. Unless they are founded on an affidavit, those we cannot read and rely.
I am guided. Having said that, that is the end of my subject.
You had outlined the third issue, of course. You had outlined the third issue.
I adopt the submissions and pray that the court rely on those in determining the matter of costs.
Thank you, Counsel.
Thank you, Your Lordship. Allow me on behalf of the third interested party to urge you, Your Lordship, while the conservatory orders were not deserved and ought to be discharged. My Lord, we rely on our written submissions dated the 30th of September 2024.
Dated
30th September 2024, and the case laws embedded on those submissions, Your Lordship.
Yes.
My Lord, I will submit to you on 3 limbs. The first is on public interest. My Lord, the second is on the question of nugatory. And my Lord, lastly, on the balance of convenience. My Lord, my departure point is Article 1 of our Constitution.
Yes.
And which, my Lord, provides that all the sovereign power belongs to the people. And my Lord, under Sub-Article 2, the people are allowed to exercise that sovereign power either directly or through the elected representatives.
Yes.
My Lord, the people of Meru County through the elected representatives, being the members of the county assembly, elected to impeach their governor.
Yes.
My Lord, the propriety of the procedure which they followed was clear, and I believe it has been well explained by the respondent in this petition. My Lord, public interest, I would want you to be guided on what the Supreme Court has said in petition number 10 and 11 consolidated of 2024. That is the case of Dock Workers Union and Okio Mutata versus KPA and others.
Yes.
And your Lordship, the Supreme Court was very, very candid that the third ground that a court should consider while granting or denying conservatory orders is the impact of such orders beyond the parties to the case, and should the order be granted or denied, what is the or maintain the conservatory order, as this petition is going to be rendered nugatory. My Lord, we humbly submit that the position of a governor, with all due respect, your Lordship, is not personal to any individual. It is a constitutional office. The holders of that office are public officers within the meaning of the law.
Yes.
My Lord, no person can cling or individualize the position of a governor. As such, your Lordship, the law provides for mechanisms of removal of a governor, and that is exactly what has happened in the matter before you, my Lord. My Lord, it is trite, and the court was kind enough to read our mind, which is also in our submissions, that indeed, even if the governor was to be found to have a meritorious petition before you,
Yes.
you have powers to reinstate her to office. My Lord, you have powers to order that she be paid damages. My Lord, again, you have powers to issue any appropriate orders that will remedy her as a person of the governor. My Lord, as such, Article 182, Sub-Article 2 of the Constitution also provides why there will be no vacuum, because a deputy governor will be able to take office and discharge the functions of a governor. As such, your Lordship, there is no issue of nugatory or the petitioner or the petition being rendered nugatory before you, because the law has provided safeguards, sufficient safeguards over such a matter.
Yes.
My Lord, if you allow me again, I had my colleagues submit that there is no way of dealing with a deputy governor who presumes office. And my Lord, I would want to refer him to Article 182, Sub-Article 6 of our Constitution,
Yes.
which provides that a deputy governor can as well be removed.
Article 182, Clause 6.
Sub-Article 6,
Yes.
which, my Lord, provides that a deputy governor can as well be removed if he does not act within the Constitution provisions. My Lord, you've also been told that the petition will be rendered nugatory because the county executive committee and the cabinet will be kicked out of the office because the governor has been impeached. My Lord, with all due respect, that position is inaccurate. Those persons are constitutional office holders elected or nominated or given that power pursuant to legal provisions. In fact, their terms run for 5 years. And my Lord, the mayor, deputy governor, does not mean that those persons will as well go home. My Lord, you've also been urged that in regard to section 33(8) of the County Government Act, and my Lord, is a humble submission before you that that provision of the law enjoys the presumption of constitutionality. My Lord, in any event, and with all due respect again, the issue of section 33(8) in Meru, which is still pending and which has not been prosecuted. My Lord, with all due respect, without going into the facts of the matter as an interested party, you are urged that there was an existing court order barring the impeachment process. My Lord, our first question is, was the Senate a party to those proceedings? My Lord, our second question is, if indeed there were proceedings that barred the impeachment process, as the petitioner filed in the contempt application in that court. And my Lord, if they want you to deal with the issues of section 33(8) of the County Government Act, have they sought a consolidation of the two petitions so that this court is then embodied to deal with that issue? My Lord, with all due respect, we feel that those facts have not been brought before you in the proper way, and you're being enjoined and you're being misled with all due respect, where there is not material disclosure of the proper facts on the ground, and upon which your Lordship was misled to issue a conservatory order. As I end up argument on that point, I wish to remind ourselves that the term of the petitioner as an elected governor is not indefinite. It's only limited to 5 years. The law anticipated that that term can be stopped or curtailed through a legal process. That is what has happened, Your Lordship, and there is nothing illegal about that. As such, the petition before you cannot be said that it will be rendered nugatory when a legal process has taken place. My Lord, allow me to go into the question of balance of convenience.
Yes.
Your Lordship, allow me to pose a question. What would happen if Your Lordship maintains the conservatory orders in this matter and eventually finds that the petition before you is not merited? My Lord, the people of Meru, the voters of Meru, one of whom I represent before you, will continue the suffering they have endured since the governor took office, and they are enduring in the current stalemate in Meru County. And Your Lordship,
apologies, I object to that. A learned colleague like my other learned colleague did file an affidavit. The question of people of Meru suffering is a purely factual issue that can only be brought to the attention of this court above an affidavit. I urge that he strongly instructs from submitting such a factual issue without an affidavit, because we want to know the particulars of suffering, or that we deal with them one by one.
Remy,
yes, Your Lordship.
Please limit yourself to the scope of your submissions.
Thank you, my Lord. I will limit myself. I allow your lordship to look at the facts from the parties who have filed affidavits of fact. Thank you. My lord, on the balance of convenience, I was submitting that in the event that you find that this petition was not merited, and by that time the voters of Meru County will have endured the lack of a proper governor for the county, and that, my lord, with all due respect. Yes, my lord.
Mr. Ngoy has not raised to his feet, but I think you can reword that.
Thank you, my lord. Thank you, my lord. Thank you, my lord. My lord, allow me to leave that and move to my second limb of argument, where the balance of convenience, my lord, we feel that favors the lifting of the conservatory orders. Yes. My lord, we humbly submit that it will have been, with all due respect, unfair to the people of Meru County to have endured a process whereas they could have sworn in their deputy governor and proceeded with the management of the county affairs, while the governor finds justice in the petition before you, without a conservatory order being in place. My lord, with all due respect, we also want to look in the question of the status quo.
Mr. Kirimi,
yes, Your Lordship.
If I'm to understand that point that you just made, you're saying that there is a balance of convenience where each party, each side gets something. So the voters get a new governor, the petitioner gets to argue their case, and at the end of the process, if the court reverses the decision and the actions that were made, so be it. If not, then no harm is done. Is that what you're saying?
But we are saying more than that, in the event the court finds that the petition is also merited, it is clothed with sufficient means of remedying the governor. It can order damages, it can order reinstatement, it can issue appropriate orders, Your Lordship, that will assuage the governor.
I'm trying to see how you can frame this without having to fight an affidavit, because you do represent the interested party who is admitted because they are a voter. Perhaps it is impossible.
Thank you, Your Lordship. Thank you, Your Lordship. My Lord, I wish to also submit that the question of status quo as escalating from the Senate,
yes,
and as escalating from the members of the County Assembly of Meru who are not parties in these proceedings,
yes,
is that their governor stands impeached.
yes.
My Lord, in my humble view, the balance of convenience tilts in favor of maintaining the status quo that has been adjudicated by at least another arm of government.
Yes.
My Lord, we further urge you that the fact, and if you allow me, this goes to the issue of joinder, which we've also submitted on, the fact that, Your Lordship, the members of the County Assembly were not enjoined in these proceedings, neither was the Senate itself enjoined in these proceedings. We humbly submit that that omission is fatal for the following reason.
Yes.
My Lord, the mover of the motion of impeachment, the owner of the motion of impeachment, is the people of Meru through their elected representatives. With all due respect, Your Lordship, they are the mothers of the motion. My Lord, failing to enjoin them in the proceedings before you, we humbly submit was mischievous, with due respect to my colleagues. And Your Lordship, I wish to distinguish the case that was cited before you. Primarily, that is the Speaker of National Assembly versus the Center for Rights of Educational and Awareness and 7 others.
Yes.
My Lord, that particular matter before the Court of Appeal did not emanate from impeachment proceedings.
Yes.
My Lord, the role of Senate in impeachment proceedings is unique and peculiar. My Lord, the role of the members of the County Assembly again in the impeachment process is also quite unique.
Yes.
With such a lordship, the non-joinder of parties in that particular matter, where the court said did not go to the issue, did not affect the fundamental rights of the parties, cannot be the same as a matter involving impeachment of a governor. And there's such a lordship, that matter is not on all fours like the matter before you, and is quite distinguishable. My Lord,
going through your submissions,
yes, Your Lordship.
and also those of the respondent,
Yes, Your Lordship.
there was quite some ground covered as to prejudice, where essentially this court is being invited to interrogate the constitutionality of parties that are not before this court. You've alluded to it being the Senate and then the County Assembly. Can this court safely give orders at the end, or even at the interlocutory stage, that affect parties that are not before this court?
My Lord, we humbly submit that this court should not issue orders affecting parties who have had an opportunity to espouse their position before you. Your Lordship, I wish to remind the petitioner perhaps that the person they have sued, that is the Speaker, does not even hold a voting right in Senate. So the Speaker is not per se directly the owner of the motion that went on to impeach the governor. The real people who impeached the governor is the Senate and the members of the County Assembly from Meru, whom my client participated in electing. Your Lordship, allow me to also submit on just one issue, the one you asked about mischief, and I think we have submitted a bit on it.
But that is your time, but I'll give
Thank
you a
you.
bit more.
Thank you, Your Lordship. Thank you for indulging me. Thank you. My Lord, with due respect, the Senate understanding orders 111 foresaw the mischief that can be perpetuated.
The Senate at standing order?
111
Yes.
foresaw the mischief that can be perpetuated during a motion of impeachment, like the one that emanated the proceedings before you. And as such, Your Lordship, they limited the question of the debate of that motion. And again, in the wisdom of Senate and our constitutional makers, they also gazetted the days and the timelines for debating such motions. Your Lordship, I'm trying to go around the issue that was raised by the petitioners, that there was communication that came out erroneously without appearing to go into the facts of the issues. And my Lord, we humbly submit that that issue is amply covered by the respondent, and that mischief was cured, and that is why the communication and to come on the 20th of August, because time froze, whether it was midnight or past midnight, time froze until the motion was debated and concluded. Finally, Your Lordship, with all due respect, allow me to associate fully with the submissions made by the respondent before you, and urge Your Lordship to kindly vacate and set aside the conservatory orders that are in place and that have made the people of Meru continue suffering. My Lord, good afternoon.
Good afternoon to you. I'm glad it's catching up.
Thank you.
Mr. Ngoya, you had indicated 10 minutes in rejoinder.
Yes.
Having listened to your colleagues, I don't think 10 minutes will be sufficient. Can we try? Let me give you 20.
I appreciate.
But try to keep it under 20.
Thank you so much.
And it is rejoinder.
Thank you.
So direct responses to what was
For the 20 minutes, I will use 15 minutes. My learned colleague, Mr. Mutuma, will use 5 minutes. Let me go straight to the point. But let me begin by asserting that it is sound principle in constitutional interpretation that a constitution must be read as a whole. Let me just begin by asserting that as a principle and make the following then statements of rejoinder. It has been said that what is at issue here is the sovereign power of the people of Meru. Let me summarize that as the issue. To that, we respond as follows: that it is true that all sovereign power first belongs to the people of Kenya, with a rider that it shall be exercised only in accordance with this constitution. Only in accordance with this constitution. The petitioner is telling you that this rider has been violated. That's what the petitioner is telling you. This rider has been violated. That this power has been exercised in violation of this constitution.
Yes.
The second issue that has arisen is that the petitioner has no, may I call it, private or proprietary interest in the office of governor. A submission was made to that effect.
Yes.
Again, let me read Article 38, Clause 3, Paragraph C of the Constitution. Article 38, Paragraph 3, Article 38, Clause 3, Paragraph C. It says, every adult citizen has the right, without unreasonable restrictions, to be a candidate for public office or office of a political party of which is a member, and if elected, to hold office. The governor is saying, I have a constitutional entitlement to hold office unless I am constitutionally removed. And he's saying the removal here is unconstitutional. We are making an argument, my lord, whether or not it was or it was not constitutional is a matter for trial in the main petition. But we are saying, in the meantime, let us stop disturbing the status quo. Let us hold matters as they are. I'll address you on this issue of status quo because it's an issue by my colleagues on the other side shortly.
Yes.
Number 3, again, my learned colleague for the third interested party iterated the issue of joinder of the speaker, and the speaker having no voting at paragraph 57 of the judgment in the case of the Speaker of the National Assembly versus the Center for Rights, Education and Awareness. Where paragraph 57. Paradoxically, the argument was precisely the same argument. It went, I would read it, my lord, without asking you to regurgitate it, just for a full tenor. The appellant, understandably, as we do here, protests that the Speaker has no role in initiating bills and does not even possess a vote in support of or opposition to a bill. And for that reason, he cannot be sued by the failure by Parliament to discharge a constitutional mandate to pass legislation. Same thing here. The Speaker does not bring the motion, does not vote on it, and what does the Court of Appeal answer? The Court of Appeal answers, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent for the following reasons. Then from paragraph 58 through 59, reasons are given. Same argument, same principle. My colleague says he wants to distinguish. How? The Court of Appeal is saying, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent. The petitioner is saying, in relation to her, the Senate has violated the Constitution. The Court of Appeal is answering, the correct respondent is the Speaker. And let me ask my colleagues the question I've asked other colleagues before. Let's assume they are right. And you are sitting there, my lord, with a Court of Appeal in front, decision in front of you as well. What do they want you to do?
What do they possibly want you to do? I think sometimes, as Jesus Christ said, it is written that they shall not put me to temptation or something like that. What do they want you to do, possibly? Having said that, let me move to another argument. The question is, what is the status quo? And before I go to that, my lord, allow me to finish that point of joinder. Let me just finish that point of joinder before I go to that point.
Yes.
What is the prejudice that the respondent in this matter has possibly suffered by joinder of the speaker? We submit none. For example, the replying affidavit to the application for conservatory orders and to the main petition was prepared and sworn by Mr. Jeremiah Nyegenye, clerk of the Senate. Meaning, the respondent clearly understood that he was sued on behalf of the Senate, and that's why he chose a competent officer of the Senate to prepare the affidavit and file it. I want to finish that point by saying that that repeated argument has no justicial priorities.
Yes.
I had made out an argument now that of August 2021, the Senate passed a resolution to remove the governor of Meru from office by impeachment.
Yes.
It is also true that under Article number 23, Clause 3, Paragraph C of the Constitution, this court has constitutional power to issue a conservatory order. And therefore, these two powers were exercised. Parliament exercised its power under Article 181. Court exercised its power on 21st of August 2024 under Article 23(3)(c). The proper question then is this: these two powers having been exercised by these constitutional institutions, what is the status quo? And the answer becomes, the status quo pursuant to the conservatory order issued by this court is what we call the status quo ante, the status quo preceding that action of the Senate. So what is that status quo? Honorable Kawira Mwangaza was and remains the governor of Meru County. It has been alleged that there was material non-disclosure, or that this court was misled in making the conservatory order of 21st of August. First, my lord, in my other word, I'm a teacher.
Yes.
And I get disturbed a little when things are made that disturb my intellect.
Yes.
The order from the High Court in Meru was produced and attached to the petitioner's affidavit as Annexure KM3. It was produced and given to you.
Yes.
There is a strong presumption that you read that order yourself, given to you, and issued an order. How can the petitioner, who has presented the full ruling of the court, be accused of material non-disclosure? I kept telling my colleague, Mr. Mutuma, I need new schooling on non-disclosure. There can be no better disclosure than actually presenting the physical copy of the ruling for the court to read by itself. Let me then get to the second limb of this argument. The court in Meru began by framing the issue before it, then gave an order. Let's see the issue as framed and the order as given. when you look at annexure KM3, at paragraph 1, the court said, this court but I hope my few minutes are frozen.
Yes.
Thank you so much.
This is begins at page 9.
Correct.
Yes, I'm there.
That ruling. If you can, it says, this court has to make a decision as to whether to grant interim orders or preserve a status quo or not. So the issue before the court is not limited to a particular motion. The issue is whether to preserve a status quo or not. Then, if you got now page 12, which is now page 4 of the ruling.
Yes.
Page 4 of the ruling, the court then makes the order. The upshot of the above is that the impeachment process is halted, not the impeachment motion. The impeachment process is halted. The court is saying, I'm halting the process to preserve the status quo. How can my colleagues say that this was not an order before this court? While at it, if you look at the supplementary affidavit of the governor, both at paragraph 8 of that affidavit and annexure BKM2 to that supplementary affidavit.
Yes.
The moment the county assembly approved the impeachment motion, learned counsel for the governor, Mr. Mutuma, wrote to the Speaker of the Senate, drawing the Speaker's attention to this court order.
Yes.
The letter you'll see on the face of it is stamped by the Speaker, who is the respondent, and stamped by the clerk, who is the deponent of the affidavit of the respondent. My lord, how can my learned colleague make an argument that the Speaker was not a party to that suit? Doesn't the Speaker of the National Assembly have an obligation under my apologies, the Speaker of the Senate, yes, have an obligation under Articles 10 of the Constitution to uphold the national value of the rule of law by virtue of his office? How can a Speaker who knows of a court order, as was done in this case, and continues to allow debate in violation of that court order, come and claim I was not a party to those proceedings? I mean, that is bad governance in a class of its own. It is good governance topsy-turvy. It should not have been done in the Senate. It was done. It should not have been done in this court by officers of this court. They must join us in frowning upon this conduct of these two officers, because our own oath of office as advocates gives us obligations beyond our clients, which is the obligation to uphold the rule of law. So, my lord, you will see at a second level the response by the government. In response to the motion at the Senate, she made that claim that there are pending court orders. You will see the debate by Senator Halwale in the proceedings of the Senate. He asked the Speaker to consider that all those things are in the affidavit in support of the main petition. And therefore, anyone to argue there was no court order, that is not being very candid with this court. And that should be,
for the completeness of my record.
Yes.
The ruling, let's bring it back up. The ruling dated 24th of July 2024 by my brother Kassan J.
Yes.
It concludes,
yes.
This is page 12 of your bundle.
Yes.
The upshot of the above is that the impeachment process is halted.
Yes.
pending my ruling.
Yes.
And since this is a matter of public interest,
Yes.
the rulings into brackets,
Yes.
PO, interested parties and main petition will
Yes.
be delivered on Monday, the 29th day of July 2024.
Yes.
Via email to all parties.
Parties, yes.
Was this ruling delivered?
No, it wasn't delivered. In fact, the judge recused himself from the matter before the ruling was delivered, and the ruling was subsequently delivered by your brother, Justice Murithi, long after this impeachment process, dismissing the PO.
Ruling
Yes. Malada, no. Just check the page after that ruling. Is there an order of court dated 29th July?
I have an amended order.
Order, yes, that one. That's what transpired on the 29th. Whatever you see there is what transpired on the 29th. Yes.
J dismissing the PO.
Yes. And you'll notice that the ruling was deferred to 20th August by Order 5.
Mr. Ngoya, is that ruling dismissing the PO, is it before me?
No, it is not. It happened quite recently. Long after this petition was filed. I'm just trying to remember the date, but it's a much subsequent development, long after we filed this petition, this application. I just answered it because my lord, you raised it.
Mr. McKenna, would you have an objection to the petition of filing that ruling so that I can see it? In reality, I can obtain it, but that is not the proper way of doing it. It should be placed properly because there's been a lot of reference to that process and what it is. Should we have that ruling before this court?
I will not object to that. I mean, not
Correct.
just
Yes.
No problem.
Be no argument.
No arguments. Yes.
You don't even need to put it in an affidavit.
Yes.
You just file it in CTS.
Correct.
And you serve your counterparts electronically.
Correct.
Don't worry, your time had been
Frozen.
frozen.
Yes. Allow me just to submit on the question of prejudice, because that again has been raised. And if you look at the Munya decision, which is, I think, to my mind, the locus classicus on the question of conservatory orders.
Yes.
The Supreme Court gives us guidelines on granting conservatory orders. We must look at the impact of the decision beyond the petitioner. That's essentially what the Supreme Court is telling us.
Yes.
And let's just try to reflect on this, the legal consequences of not preserving this conservatory order. Article 179, clause 9.
Yes.
Article 179, clause 7 of the Constitution says, if a vacancy arises in the office of the county governor, the members of the county executive committee appointed under clause 2B cease to hold office. So this is a legal consequence. When my colleagues say they can continue, how? They don't say they must stop holding office. Let's try to think about the public interest on this, my lord. It will mean
Yes.
the deputy governor once sworn in then must appoint new CECs, because those others stopped holding office by operation of law. It's not a discretion on the part of the governor. Hiring those new CECs means, my lord, taking them through the vetting process at the taxpayer's expense, the approval process at the taxpayer's expense.
Yes.
It means replacing now the deputy governor, because the deputy governor has assumed the office of governor, It means replacing a deputy governor now at the taxpayer's expense. When we call it saying the governor can be compensated, who will compensate these taxpayers? This is irreparable damage, my lord. This is I've never seen more irreparable damage than that.
Yes.
They will come into office, they will be entitled to the usual things, medical cover, their mortgages and grants, if any, provided by SRC. These are all consequences. So that if you eventually return the governor to office, it also follows that that deputy governor who assumed the office of the governor has vacated office, those CECs also vacate office. The governor again begins another process of hiring CECs and other senior bureaucrats.
Just a moment.
I'm just looking at the legal consequences only.
Just a moment.
Yes, I appreciate.
So if these conservatory orders were lifted,
Yes,
and then the petition succeeds,
yes,
there would be need in the orders for the CEC members
Yes.
who have come in
yes,
to be removed,
correct,
the new DG
yes,
to be removed,
correct,
and the status quo ante
Correct.
to be re-established.
correct.
That is your submission.
That's my submission. And I'm just saying about operation of law. There's no discretion. Because my colleagues kept saying that who said he must remove the CEC. The law itself says once this one leaves office, those CECs leave office. They can only come back to office by reappointment. And my lord, when you begin reappointing, it's a fresh appointment. It's like the other day, my lord, when the president removed CSS from office, and now I'm just giving I'm just giving an example. I'm giving a matter in the notorious. Apologies. Okay, I'll leave it at that. But I'm saying by operation of law, Article 179(7), they must go, then get appointed or fresh ones appointed by the DG who assumes the governor. Then assume the petition succeeds. Those ones whom the DG had appointed must also go by operation of law, Article 179(7). Then the governor returns to office and begins another appointment process. I'm making that a simple argument, my lord. This is overwhelming expense to an already burdened taxpayer in Meru, like all of us.
Yes.
Compare that, my lord, to a matter that is within our control completely, where we can break our backs in this court and say in the next 1 month, in the next 2 months, we must finish hearing this petition so that the chips fall into their place. This is a very proportionate way of use of power. We finish these matters, the chips fall in their place. If the governor is going, as the young people selling in the streets, anaenda akiendanga. She has lost, she now goes completely. If she's remaining, she remains. That is more within our control. It saves the taxpayer, the public significantly. I urge.
5 minutes.
Thank you so much. I want to rest at that and invite my learned colleague, Mr. Mutuma, to then use the 5 minutes to make the argument I wanted to make. And thank you so much for the audience, and a good afternoon, my lord.
Mr. Mutuma?
Yes, thank you, my lord. I'll just buttress one issue on whether the governor is capable of being compensated by way of cost.
Yes.
My lord, assuming that that was a possibility, that cost would be paid by the respondent, the Senate, the Speaker of the Senate,
Yes.
using taxpayers' money. So it would still be against public interest to compensate the governor using taxpayers' money. That cannot be an option, my lord.
Yes.
Two issues, my lord. One is still on the issue of prejudice. You would have expected, my lord, just like I did, that the respondent and the third interested party would demonstrate the kind of prejudice they would suffer if conservatory orders remain in force.
Yes.
I must state, my lord, that none of them has even alleged the kind of violation or prejudice that they would suffer should the conservatory orders remain in force.
Yes.
The Speaker of Senate, being a neutral arbiter in the matter and having discharged his mandate,
Yes.
no longer has any prejudice to suffer, whether the conservative orders remain in place or not.
Yes.
There is no injury on the Speaker or the Senate. They have not even alleged that they have any prejudice.
Yes.
On the part of the third interested party, he appeared in court wearing the public interest hat,
Yes.
and we all agree, my lord, that public interest is a key consideration in this matter, in granting or denying conservatory orders.
Yes.
The question that we are not agreeing on is where does that public interest lie?
Yes.
The governor before you was popularly elected by the people of Meru. There has been only one voter who has come before you to allege that they are unhappy with the conservatory orders. No other voter.
Perhaps in rejoinder,
Yes.
you shouldn't go down that road, because they have not filed an affidavit. I do have a pending number, I think 2 applications for joinder. Perhaps we can just limit it.
Thank you, Barot. So my submission in respect to that issue is that the third interested party ought to have demonstrated by way of an affidavit the kind of prejudice they will suffer if conservatory orders remain in place. They have failed to do that.
So, Your Lordship,
Yes.
that would not be fair to us.
No. You don't address Mr. Mutuma, Mr. Kibini. You've been in practice for very long time.
Indeed.
You address me.
So, Your Lordship, with all due respect, I think it would not be fair to the third interested party on that submission that we did not file evidence. And whereas the court elections were clear that there is a great value of submissions, it is not out of wish that we would file. Does that mean they file evidence? Let him limit himself to the issue of the law.
So Mr. Kibimi and Mr. Mutuma, I think that may not be a large issue. My recollection is that this was by consent, and the parties agreed that the fastest way to move to this day would be by the interested parties being limited to filing on the submissions. And that is why, Mr. Mutuma, when you began that route, I tried to navigate you back. So
Thank you, my lord. On the last issue is that you will note
Yes.
from the response by the respondent in this matter,
Yes.
they have not bothered to in any way controvert the allegation that the proceedings at the Senate were marred by violence, chaos, and disorder, making it impossible for a fair trial to take place.
Proceedings of the Senate were marred by
Violence, chaos, and disorder, making it practically impossible for a fair hearing to take place. They are the custodians of proceedings at the Senate. They have not denied that indeed there were chaos. My Lord, we invite you to look at paragraph 58 all the way to paragraph 60 of the supplementary affidavit. We have taken time to extract verbatim
Paragraphs?
58 all the way to 60 of the petitioner's supplementary affidavit.
Sorry, that is your time, but I'll give you a little bit
Yes,
more.
I'm concluding.
58 to 60?
Of the supplementary affidavit,
Yes.
we have taken time to produce verbatim extracts of what transpired at the Senate. Specifically, paragraph 58 attaches the Hansards that confirms indeed the Senate became ungovernable with the Speaker of the Senate doing nothing to bring the House to order.
Yes.
The petitioner was doing a joint submission. They won't have a chance to respond to some of the issues that take place. What chaos in the house and such.
Well, these are matters that we must oblige.
Now, Council, it is not for this court to direct, but what I recorded, you say, just a moment, I've written quite a lot, I have to find exactly where I recorded you. The proceedings at the Senate were constitutional and regular. Now, if you say that in your highlighting aspect, then the petitioners, counsel in rejoinder, have some latitude to point out to why they think they are not constitutional and regular. But I do take your point, so counsel, don't stray too far.
I'm actually concluding, my lord. The point I'm making before I sit down is that the proceedings cannot have been said to have been regular. The proceedings could not have afforded the petitioner the right to fair hearing as envisaged under Article 50 of the Constitution.
Yes.
In light of the violence, chaos, and disorder.
Yes.
We fault the Speaker for failing to bring the House to order, to generate a conducive environment for a fair hearing to take place. That fact having not been controverted, it remains an issue that can be comfortably said to have been admitted. On that basis, my lord, it is our humble submissions that the applicant in this matter has met the threshold and criteria for issuance of conservatory orders. The balance of convenience tilts in a favor. Public interest is in favor of granting conservatory orders, and there would be absolutely no prejudice on the part of the respondents or indeed any other party if conservatory orders are maintained. On the contrary, the damage would be irreparable both to the petitioner and the public should the conservatory orders herein be discharged. On that basis, my lord, we wish to rest our case and wish you a good afternoon.
So that marks the close of highlighting of written submissions on both the application for the conservatory orders as well as the counter application by the respondents. ordinarily, I would be proceeding to issue yourselves a ruling date on both applications. I am not able to do that today. I think, Councillor Mwangaza, you noted you have not paginated.
Yes.
May
I remedy that right away? I've paginated, so I can withdraw that and give you a paginated version. So that I just remedy right away.
You will do that administratively with our Mr. Guyo. The other issue is on your submissions. Mr. Guyo will engage with yourselves. He'll give you my court email address so that I can have your submissions in Word, not the annexures, just the text of it. We can have a mention, because I don't want to take us too far. Mr. Guyo? It's just to confirm compliance and to take a ruling date. Now, Thursday is a public holiday. I know it is likely that persons will have traveled. Can we say Tuesday next week? Any objection? It will be virtually. 15th October, any objection? Now my fingers have been burnt when I've done that, where when I retire I find there's been no compliance, and then I have to issue a date calling for my previous date. 15th is not too far away. So make sure everyone has filed everything. I also encourage you, because I've not gone through every page of every volume. Mr. Guyo, help me with volume 6. So this is volume 6 of annexures. It runs to page 3742. I encourage all parties to ensure that what you've uploaded into CTS is legible. I can clearly read it. So just go in and confirm. And also you can help me, you can assist me greatly by giving me hard copies. So we'll be coming on Tuesday to confirm that, so that I have hard copies that I then use for a ruling. Now, Mr. Kirimi, I hear you. Let me assure you that between myself and my able Mr. Guyo, we already have a date, and that is the date we will be informing you on Tuesday next week. So, Council, thank you very much for your patience and your very, very good submissions. Let's meet on Tuesday.
But I don't go away with this document. Yeah, this is the one that we have like this. I'm going to take that out, so that's our confusion. I'm just hoping it's near. I want us to retrieve that one.
Nganga KT News, Nairobi.
Well, the early bird doesn't just catch the worm. Red Bull gives you wings.
New Super Stay Skin Tint. For a bright, fresh look. Maybelline, New York.
Ukurugenzi, kwa nini wasichana wa St. Louis wanapenda kuvaa nguo fupi fupi? Sababu wako na miguu mizuri.